Good evening. Welcome to the Facebook fan page and the YouTube channel for the Law Office of Travell, Travis. Our firm focuses on the needs of pastors, entrepreneurs, creatives, and the community. We invite you to connect with us via our website, travelltravis.com, telephone number, area code 757-528-8529, email travelltravis@gmail.com, as well as social media, Facebook, Twitter, LinkedIn, Instagram, and YouTube. We ask you to please like, share, comment, and tag. Our videos are for educational and advertising purposes. It is not a substitute for consulting a licensed attorney in your home state. On March 27, 2020, in response to the COVID-19 pandemic, President Trump signed into law the CARES Act, which stands for the Coronavirus Aid, Relief, and Economic Security Act. In addition to stimulus checks to individuals and families, it included one, assistance to small businesses, known as the PPP or the Paycheck Protection Program, and it increased and extended unemployment benefits to include entrepreneurs, those who are self-employed, independent contractors, and what is considered to be gig workers. Unfortunately, many churches and many church employees did not qualify for any of the $2 trillion in relief aid, largely due to poor records, lack of contracts, written contracts, lack of filings, and too oftentimes payments made by cash only. Unlike for-profit businesses that pay taxes, unlike for-profit businesses that pay taxes, those businesses must report payment to people who perform services to their business in order to write off those things as a business expense, thus reducing the tax liability or the amount of taxes owed by that business. However, a church, as a tax-exempt entity, doesn't have to do this. And so thus many churches do not have the same incentive or arguably liability for failure to report expenses or reduce tax liability. However, because the church is tax exempt, does not mean that employees are also tax exempt as well. Those who work for the church are still responsible for paying federal tax, state income tax, as well as perhaps paying into Social Security, FICA, Medicare, also other taxes that may go along with being an employee in that particular state. Which leads me all to the next question: who are employees? Not everyone who works for you works for you. Let me say that again. Not everyone who works for you works for you. Those you pay for services rendered are either W-2 employees or 1099 independent contractors. And so the way to distinguish is not so much the amount of hours worked. So a lot of times we say, well, they're not full-time 40-hour-week employees, but the amount of hours is a factor, but it's not the determining factor as to whether or not a person is an employee or independent contractor or not. The IRS looks at 21 factors, what they call the right to control test. They look at time, place, manner, oversight, how much autonomy, who provides resources, who determines the schedule. Is the person considered to be in their own business or part of some essential part or component of the primary business? And so it's one thing if you are a law office hiring a plumber, different than a contractor who may have a plumber on staff, because plumbing is a part of construction, whereas a plumber who's brought in to fix the office of a law office, that's a service provided to the law firm but isn't necessarily an integrated part of that particular law firm. Also, in many churches, you have unpaid volunteers, but once you start giving money in exchange for services, whether it's a gift, a token of appreciation, a love offering, a stipend, or a salary, it can potentially be a game changer for your church or ministry. If, once again, the person is an employee, not only does that employee have to pay taxes, federal tax, state taxes, perhaps Social Security and Medicare, but also the employer has to withhold those taxes. And in case of FICA or Social Security or Medicare, the employer has to match it. Also, the employer has to pay into the unemployment system. There's other workers' compensation laws, various paying into the pool for unemployment, as well as various other employment laws that may apply if that person who works for the church is truly an employee of the church versus an independent contractor or an unpaid volunteer. And so if the person is an independent contractor, essentially you pay them, you report to the IRS that you pay them, but they're responsible ultimately for paying their own taxes and other expenditures. On the other hand, if the person is a W-2 employee, then now you take ownership and responsibility for that person and making sure those taxes and various expenditures are covered. So in a church, it's possible that you might have 0 employees. You may have a mixture of independent contractors and employees, or you may have one or the other. But it's very important for a church to properly classify, document, and record these individuals that provide services, especially for compensation when it comes to the church. We often easily consider certain ones to be employees when we think about the pastor, ministers that are on staff, perhaps administrators or secretaries. Perhaps we pay, for janitorial services. But the question often comes up with the issue of musicians, or whether or not they are independent contractors, whether they're employees, or whether they are unpaid volunteers. You might also have independent contractors. They may provide lawn care. They may provide graphic design. They might provide web hosting, accounting services, or even specialized cleaning during this pandemic, or as well as guest speakers. They come in, they guest speakers, they're evangelists, guest pastors. You give them a love offering or compensation, but they're going on to their next assignment and not necessarily a part of your church or your ministry or regularly receiving a payroll. And so you kind of have this two groupings of individuals, or 3 really. Your unpaid volunteers, you have your W-2 employees, and then you have your 1099 independent contractors. And so the question becomes, where do the musicians fall? And this is not a conversation as to whether musicians should get paid or not. But once you get into the area of compensating musicians, then you have to make sure that you follow all of the accounting and legal requirements so that they are, there doesn't become a liability on the church or to that particular musician. And in the case now of the CARES Act or unemployment, many musicians actually have missed out because of improper documentation and record keeping. And so you may have a situation where you say, going back to the number of hours, a musician may play for more than one church. They may actually take on side engagements for a guest preacher, a community choir. They play for weddings or funerals. They might even have a full-time secular job. But the question is, are they your church musician and getting paid? And so should they be considered W-2 employees rather than 1099 independent contractors? The total hours per week may only be 10 hours. But if you think about it, if a person works at McDonald's for 10 hours, even if they are part-time, they're still considered an employee. And McDonald's is responsible for employment laws, paying into workers' compensation, making sure there's workplace safety. You have to avoid employment discrimination. They have to withhold federal and state taxes, Social Security taxes, Medicare taxes, and the like, even for that 10-hour week high school student that's only getting paid $7.25 an hour. Okay, so even though that person works minimum hours, even though that person may get minimum pay, I think we all understand that that person works for McDonald's. And so the question then becomes, does the musician work for the church, even if they're getting paid arguably minimum wage, even if they work perhaps a small amount of hours? Are they employees and therefore should be treated as such, and proper documentation should be recorded? For a 1099 employee in particular, if you pay a person over $600 or more per year, you're required to give them a 1099. And you say $600, that's not a lot, but that's really $50 a month. So when you start thinking about that I pay a musician $50 a month, or in some cases you have a guest speaker, you may give them $1,000, depending on how many nights they preach, or the type of speaker that they are, itinerant speaker, well-known speaker. And so very easily you've crossed that threshold of $600 and thus triggering the 1099 requirement. But just say for the sake of argument, no one's going to come in and do an audit of your church. No one's getting ready to come in and do an investigation over a one-time payment of $600 or a number of payments over a year that amount up to $600. Perhaps one person is not that big of a deal. Maybe for sake of argument, if you have a bunch of people that fall under that may trigger something. But let me take it a step further. What if rather than $50 a month for 12 months, you actually pay your musician $50 per week? Now we're talking about $50 per week, when it ends up being around $2,600 a year. We're clearly over now the $600 per year threshold. Now we're perhaps getting into, part-time employment money, which may actually be taxable income. $50 per week probably still below average for the average musician. Now you're starting to get into thinking about $100 per week. What does $100 per week add up to being? That's $5,200. Clearly you're in a range now where you might get the attention of the IRS if you have not treated them as an employee and issued a W-2 and withhold those taxes, or have given them a 1099 so that that person can be recognized as an independent contractor. So for churches that did not have the 1099s, the churches that didn't have the W-2s, they didn't have pay stubs, they didn't have return checks, they didn't have contracts, many of these churches were not eligible for the CARES Act Payment Protection program, which could have perhaps covered the church musicians during this economic crisis, the shutdown, the pandemic of COVID-19. Likewise, because many of the musicians didn't have contracts, they got paid in cash, not necessarily paid with a check. They perhaps did not necessarily deposit the monies into a bank account. There are no 1099 forms. They have nothing to show or to prove that they are paid musicians, independent contractors, gig workers of the church. And so many of them were ineligible for the unemployment compensation that perhaps could have been afforded to them because they did not have proper documentation. So in closing, for this post-pandemic era, I encourage churches, once you get into paying people for services, especially if it's over $600 or if it's on a continuous basis, that you consult a tax attorney or an accountant, especially those who are familiar with nonprofits or churches or church law, to ensure that those who are getting compensation are properly classified. Whether they're independent contractors, they should be getting a 1099, an employee that gets a W-2 form, or simply a volunteer that truly is getting a love offering. Because when you start thinking about $600, just say this, you give your musicians $500 a year during the annual musician appreciation service. Or you give them $200 at Christmas, $200 at birthday, $200 at annual appreciation service. You might just say, okay, they got something that's not really salary, that's not really compensation, that's just really a love offering, it's under $600. Maybe that we can kind of keep it under the table. But once you start getting into a weekly, monthly, per service, continuous relationship, paying a musician, especially once you get past that $600 a year, you start getting into that $50 a week, which brings you up to $2,600 a year, or that $100 a week, which brings you up to a $5,200. And some of your musicians in some of your major cities and some of your major churches, I mean, they're getting $1,000 per week, $50-some thousand a year. So the amount of money that you're paying is a factor, but it's not the sole factor. It goes back to that 21 factor test, right to control test that the IRS gives out. It also goes to whether that, when we think about being a musician, integrated role, musicians are an essential part of church. That's not the plumber who works for the construction firm. That is more, forgive me, it's more of the contractor, the plumber working for the construction firm, than the plumber that comes in to repair the leaking pipes at the law firm. Okay? And so considering that that person is an integral part of the ministry, the function of the church, how the church operates, how it ministers, getting paid on a regular basis, whether it's by cash or by check, whether it's over the table, under the table, it is important for churches and musicians to make sure that they're properly classified, that they have proper documentation, and that they are paying taxes if necessary, so that in an event where a pandemic comes up, now there's a CARES Act, there's payment protection program for churches, there's unemployment compensation for self-employed, independent contractors, gig workers. They can actually qualify for some of these benefits. So to ensure proper classification, documentation, make sure that you have contracts where necessary, do the proper withholdings to avoid both liability on the individual as well as liability on the church. Both the individual can end up having tax liability, which can be civil as well as criminal, as well as the church can also fall into civil as well as criminal liability for misrepresentation, misclassification, not withholding proper taxes as should take place. So for a musician, talking about negotiating contracts, a couple of things that I want to highlight in closing. Contracts do not have to be complicated. A lot of times people feel like, it's a contract. It has to be this 10-page legalese document. But the contract doesn't have to be that complex. It really even shouldn't be. It should be in plain English. Good grammar, good punctuation. There's some legal terminology that has some ramifications. But generally speaking, a plain English, well-written document that clearly defines the terms of the relationship is generally sufficient. Don't leave your agreement to chance, to memory, to interpretation, simple routine or practice, or this trust of the party. I've often said, I trust you, but your memory is unreliable. So I trust the person, but your memory is unreliable. So put it in writing to preserve the relationship, not to pervert the relationship. People think, put it in writing, you don't trust me, why we got to get legal, why we got to treat this like business. But in order to preserve the relationship, in order to maintain integrity, in order to, avoid legal liability, to make sure that God's blessing is on the relationship, that covenant, that contract, things should be done properly, both biblically as well as legally. Also in that contract, a couple things you want to include is, what is the salary? Are vacation days included? If I'm a musician, 52 weeks, how many Sundays can I just take off? Do I have sick days? Do I have personal days? I just don't want to come today. May not be vacation, may not be sick. Who's responsible for coverage in the absence of the musician? Musician is out of town, musician is sick, musician on vacation. Is it on the church to find a substitute? Or is it on that musician to find a substitute? Or is there a list of subs that perhaps one could call in, on a advanced or even short-term notice? What if there's durations of the relationship in terms of how long is your this relationship? Is it at will? Is it month to month? Is it semi-annual? Is it annual? Is it multi-year contract? How would a person be paid? Is it per hour? Do we calculate how many hours for praise team practice, personal practice, Sunday morning service, Sunday evening service, or if a church has multiple services? Are they paid per hour? Are they paid per event? Flat rate per event. Okay, we got 3 services this week. You get paid X amount of dollars per service, regardless of whether you pay, 10 minutes of music or 2 hours of music. Or are you paid per week, regardless of the amount of services that take place? What's the frequency of pay? Is it per service? Is it per week? Is it bi-monthly? Is it monthly? Are there additional qualifications to get the job or retain the job? Maybe you have a requirement for attire. You want your musicians to be in church attire, and you don't want them coming in ripped jeans and a t-shirt, sweatpants and a hoodie. And so is that in the contract about attire, lifestyle? If there's some issues of, sin or lifestyle, is it in the contract that says, this person can be terminated because of known or suspected questions of one's integrity or lifestyle? Are there issues of doctrine? Do you care if you're a particular faith that your musicians ascribe to the same faith? So do you have a certain doctrinal requirement? Issue of tithing comes up. Do you require your musicians to tithe to your church, the church that's paying them? Or are they free to tithe wherever they choose? Are they required to become members of your church? Some churches require that their musicians become members so that they have a more vested interest in the overall success, and that they're part of the ministry and not just a hireling, if you will, that comes in just to play to get paid, and they really don't have any interest in the success, the viability, or the future of that ministry. What about outside engagements or additional musical opportunities? Do they have to be clear? Do they have to be vetted? Or if the church has an extra revival, or a church has an extra afternoon fellowship service, or there's a special conference, or the pastor is preaching out somewhere, are those optional? Are those mandatory? Are they paid at the same rate as everything else? Is there a higher rate? And so those things need to be put in writing and not left to assumptions, or even left to, this is how we always done it. Okay, that's good practice, that's good routine, but it's not in writing, so who's bound either way if it's not put in writing, a signed agreement? And so even now, with church closures, is a musician entitled to be paid even in a church closure, even if it's just a routine church closure, like it's just wintertime and you close that Sunday for snow? Does the musician still get paid? Is that addressed in the contract? Or we're in a pandemic now in which church is closed for 2-3 months. What's the relationship? And so we're going back to the initial conversation. Many musicians could have been eligible for unemployment compensation if they had a contract, if they had a 1099 or W-2, if they had pay stubs, if they had bank records, which could have made them eligible for unemployment compensation. If the church had those records, the church may have been able to qualify for the CARES Act Payment Protection Program, in which the government would have given the church money, or loaned the church, if you will, money to cover the salaries of those during the shutdown. But because the musicians and the churches didn't have their ducks lined up, if you will, the church couldn't get the money to keep paying them, nor could the musicians qualify to get money to continue to get some type of income during the pandemic. So this particular crisis has kind of highlighted some of the sloppiness, if you will, some of the lack of organization, record keeping, under the table business dealings that now has left both the church as well as the musician left out of the cold without any type of financial assistance during this pandemic. So I encourage you to contact a lawyer. Once again, as we mentioned, in terms of the proper classification, whether the musician is an employee, is the musician an independent contractor, is the musician a unpaid volunteer that maybe gets some type of love offering or stipend. At what point is the amount of money that you're paying now perhaps triggering tax implications or liability for the individual, for the church in terms of reporting to the IRS money that they paid the particular individual. Also, perhaps contact a lawyer to draft, to review, and even enforce any type of employment contracts that you may have as a church with your musicians, or quite frankly, anyone, whether it's the secretary, the ministerial staff, the janitor, the lawn care provider, the audio visual. Once you start paying people, it becomes a game changer, and it should be handled appropriately and legally to avoid any type of ramifications, lawsuits, or liability on the individual as well as the church. Once again, we thank you for viewing the videos offered by the law office of Travell Travis. Our firm specializes in the needs of pastors, entrepreneurs, creatives, and the community. We invite you to like, share, tag, comment. If you know a musician, tag them. If you know a church that pays its musicians, tag them, post, share. Because coming out of this pandemic, there should be some lessons learned and some best practices shared, so that if this thing happens again, which is a strong possibility that, hey, next winter we might be in the same situation, and perhaps there's another stimulus plan, are we in position, both our churches as well as our employees, to take advantage of some of these programs offered by the government? Once again, our videos are for educational and advertising purposes and does not substitute for contacting a licensed attorney in your home state. We invite you to connect with us on social media, Facebook, Twitter, LinkedIn, Instagram, as well as our YouTube channel, which archives all of our videos. We invite you to visit our website, travelltravis.com, contact us by email, travelltravis@gmail.com, or that you call us at area code 757-528-8529. May God bless you. May God bless your ministry, your musicians, your church, and heaven smile upon you is our prayer. Good night, and God bless.